Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss the decision handed down on May 18th in Polselli v. IRS. It's my honor to introduce our guest today. We're joined again by Professor David Schizer. He is the Harvey R. Miller Professor of Law and Economics at Columbia Law School, where he also served as a dean of the law school from 2004 to 2014. He started as a dean at the age of 35, making him the youngest dean in Columbia's history. He's one of the nation's leading tax scholars, and his research focuses on nonprofits, energy law, and corporate governance. And we're very happy to have him join us on SCOTUScast today to break down a very quick turnaround of Polselli. It feels like we were just talking with you about the post-argument episode, so good to see you so soon again. So I guess starting us off, can we talk a little bit about the background of the case as kind of a refresher?
Absolutely, Justin. It's a pleasure to be with you again. And I'm back sooner than I thought. The argument was March 29th. It took the court around 50 days to come out with a unanimous opinion. So what was the issue here? The issue is once the government has decided that you owe back taxes, what are their powers in order to collect those back taxes? And specifically, how far can they go? Specifically, what kind of power do they have to get records, not just from you, but from other people? And the bottom line of the case is that the power of the IRS is fairly enormous in that regard.
All right, so I guess transitioning to the decision in the case, can we talk a little bit about the reasoning behind the decision before we get into, as we discussed, individual justices' contributions?
Absolutely. So Chief Justice Roberts wrote the opinion of the court. I have a feeling he had a good time writing this because he begins the case with a bit of humor. He says, for as long as Americans have had to pay taxes, at least some have tried to avoid them. And for as long as Americans have avoided taxes, the Internal Revenue Service and its predecessors have tried to collect them. As the old joke goes, he says, I believe we should all pay taxes with a smile. I tried, but they wanted cash. So a nice way to begin what is otherwise, truthfully, a bit of a depressing opinion, at least from the perspective of taxpayers. So there was a taxpayer named Remo Polselli. He was assessed $2 million in back taxes. The government thought that he was hiding this money, possibly with his wife, Hannah, who's one of the petitioners, possibly with his law firm, or in a way his law firm knew about. And the law firm Abraham and Rose, they're also petitioners in the case. So the government wanted information about spouse, the law firm, and they contacted their banks. They issued a summons to their banks asking for bank records, again, not of the taxpayer, not of Remo Polselli, but of his wife and his law firm. The government did not give notice to those two parties that they were seeking records, but of course they were in touch with the bank. The bank told them, so Hannah, the spouse, and the law firm brought an action to quash the summons. And the legal issue in the case was, did the government have the authority to seek these records without giving notice? And why do we care about notice? The key about notice is you have to be legally entitled to notice in order to challenge one of these summonses. So if you don't have a right to notice, you don't have any say about whether it happens. You can't issue a challenge. The Sixth Circuit said, we don't have jurisdiction here. The taxpayer doesn't have, the spouse and law firm, they don't have a right to notice here, and therefore they can't bring a suit. So that is the issue that the Chief Justice needed to resolve. And how does he do it? Very much a textualist opinion. The context is that back in the early 1970s, the US Supreme Court offered a very broad interpretation of what the IRS could do in terms of seeking records. Really, really broad, no notice, no ability to challenge. Congress didn't like it. So Congress actually passed the statute in 1976, and the general rule is notice. You are entitled to notice. You can bring a lawsuit to challenge, but there are exceptions, and this is a case about an exception. The exception focuses on what's called the assessment phase, and in the assessment phase, the government isn't still looking to see whether you owe taxes. They've already made a determination. That's their formal way of saying you owe taxes. And once the assessment has been issued, then the government does not actually need to get notice if they're going after a specific taxpayer. So that's the provision in the statute 7609. That's the provision that is being interpreted here. And the relevant language is a little convoluted, but it says that there's no notice if a summons is, quote, issued in aid of the collection of an assessment made or judgment rendered against the person with respect to whose liability the summons is issued. So if they're going after someone for back taxes, do they have to give notice? Chief Justice says, doesn't, it seems like a pretty clear exception. Now, in the court below, in the Sixth Circuit below, Judge Keflage, an appointee of George W. Bush, wrote a dissenting opinion saying the way we should read this language is there's no notice if you're going after a third party's records and the taxpayer has an interest in those records. So the idea would be if you're asking for records about Hannah, the wife, but it's a joint account between Hannah and her husband, then you can do it without notice because it's like going after the taxpayer. But if you're going after information about Hannah that's just about her and her husband has no legal interest in anything about it, you need to provide notice. The exception doesn't cover that. That's what the dissent said. And it's based on a Ninth Circuit opinion from a few decades ago. And so there was a circuit split, the Ninth Circuit on one side, the 6th, 7th, and 10th, I believe it was, ultimately on the other side. And the Chief Justice says, look, Congress could have said, this is an exception, the notice, the lack of notice is limited just to when there's a legal interest on the part of the taxpayer. They could have said that. We don't see it in the language, so we don't think it's there. Basically, the government has the power to do this. They have the power to ask third parties for information, even information about things where the taxpayer has no legal interest. That's sort of where they come out. And they say, look, we have to respond to the two arguments that the taxpayer has made on, about the statute itself and to one about policy. So in terms of the statute itself, basically what the taxpayer was relying on is the language in the aid of collection. You need to be working in the aid of collection in order not to have to give notice. And so the dissent below and the taxpayer here, they're saying, well, in the aid of collection, there needs to be some really tight connection, some reason to think that what you're doing is you're actually getting the taxpayer's asset. So you have to be looking at, say, a bank account that is partly the taxpayer's. You have to think you're going to find their assets there. And if you're just on a fishing expedition looking for, anything else, it's not in the aid of collection. Therefore, the statutory language isn't triggered here. Therefore, this exception to the notice requirement is irrelevant. The general rule is notice. So what the Chief Justice says is, well, in aid of collection, aid, help, a lot of things help, doesn't have to be that tight a connection. And they give a little example. They say a recipe might help a chef shop for needed groceries, even though more steps are required before the dinner will be ready. So the shopping list, going to the grocery store, that's an aid of making the meal, even if you're not actually cooking. And in the same way, the IRS could be trying to find out something from the law firm, not about whether the law firm is holding the taxpayer's assets, but just about something about the taxpayer that could help them find the assets somewhere else. So we think in the aid of collection, Robert says, we think the aid of collection is not a phrase that defeats the government's argument here. So then there's a second argument. And the second argument is, well, there isn't just, the general rule is notice. There isn't just the one exception that I've been talking about, the one about in aid of collection where there's been an assessment. There's a second exception. And the second exception is as follows. It says, you don't need notice if it's a summons about, quote, the liability at law or equity of any transferee or fiduciary of any person referred to in clause 1. So they're basically saying so the taxpayer is saying, listen, There's a second exception for fiduciaries, third parties. You wouldn't need the second exception if the first exception is as broad as the government is saying. If that first exception says, we don't need to give notice as long as we're going after someone and we've made an assessment. If that's really the way to read it, why can't they use that language to go after the third parties too? And so therefore, the taxpayer is saying the government's reading is so broad that it renders this second exception surplusage, and that's not the right way to read statutes. And good textualists know that language needs to have meaning, and we have to read it that way. So Roberts has an answer for that too. He says, well, the thing is, this talks about liability, not assessment. And he's referring to the fact that the government thinks there are two stages to what they do. The first is to figure out whether you actually owe the taxes. And the second is once they figured it out, they have to find your money. So what Roberts is saying is this second exception, it's about that first phase, figuring out whether you really owe the money. And there, that second exception, which is about assessment, it's about finding the money, it wouldn't apply, so they need this other language. The two have independent meaning. Roberts also observes that the first is about the taxpayer, and the second is about fiduciaries and transferees, and there could be liability for them separately. So to him, this is all distinct. So that's really the heart and soul of the court's opinion. They're saying, look, we're here to read language. This is up to Congress. As we read the relevant text, it's broad. This exception is quite broad. So the privacy protections that you're looking for, they just aren't there. But there is this policy issue. Isn't it kind of creepy that the government can just go to anyone you know and say, hey, we want to see your records because you know this taxpayer who's underpaid? And the Chief Justice acknowledges that that's an issue, but he says this isn't the case where we're going to determine the boundaries of privacy protection. It is, of course, for Congress to do, but we're not asked here to figure out exactly how far they can go.
So pivoting away from the opinion for the court, can we touch briefly on Justice Jackson's concurrence and if we learn anything about her as a new justice based on her opinion?
So I think we do. And the truth is, during the argument, I did think that the government was going to win this case just based on the questioning. I wondered, though, whether Justice Jackson might dissent, because she certainly seemed concerned about privacy issues during the argument. And her opinion is basically along the lines of, look, I agree that in this case, Polselli, he'd been paying his taxes, or he seems to have made a payment. The government knows that he's made payments, not only in his own capacity, but through entities. And therefore, the government had reason to try to find out, what are the entities that are really him? How can we tell if it's him, if it's not under his name, where would it be? And they thought that maybe looking at bank records that his wife had might shed some light, and the law firm, did he pay his fee, not individually, but through an entity? And that's what the government said they were looking for. And she said, okay, so that doesn't seem like such an extreme case, but there could be cases that are extreme. And I just want to emphasize that I don't think this authority is unlimited. So it's sort of a shot across the bow to the government saying, in this case, you win, but don't think that your power is unlimited. And then she gives another example. She says, let's say a taxpayer goes to a dry cleaner, as we all do, and the government thinks, hey, we're going after this taxpayer. Let's go to the dry cleaner and let's ask for absolutely every financial record about every aspect of the dry cleaner's business and life. And she says, look, it would seem to me that that's broader than this statute allows, but of course we don't decide it today. Now, what I found interesting about her argument is that, at least as I read it, there's no moment in her concurring opinion where she refers to specific statutory text to say there must be a limit and the limit is here. Instead, she's talking about essentially the context in which the statute was enacted. You had Supreme Court opinions like the Donaldson opinion in the 1970s that gave the government a lot of power. In 1976, Congress responds by limiting that power, saying notice is generally necessary, and then they include these exceptions. And she's saying the general rule was notice. These are narrow exceptions. just keep that structure in mind, and therefore the exception shouldn't be too broad. But the truth is, as I read this opinion, her concurring opinion, it feels less textualist than the court usually is. I don't want to go too far with that, though. Justice Gorsuch joined the opinion, and his question in oral argument was to the government, do you imagine that there are limits on your authority? And the government said yes. And I think it was based on that he felt he could join her opinion, and it wouldn't surprise me if there was a negotiation about the kind of things they said in the opinion. But I do wonder whether she might have a somewhat different take than some of the other justices about how to interpret statutes.
So in general, and kind of to wrap us up, what are the key takeaways of this argument that we should go forward with? And then also, I guess, what are the implications, or what has this teed up going forward into future court terms?
So I would emphasize three things. First of all, for those of us who keep score, the Ninth Circuit loses yet again. There they were in a circuit split on their own, and a unanimous court rejects their reasoning. This isn't the first time. It might actually not be the last time, but we will see. The second interesting takeaway is maybe just building on something I just said. This is a very textualist court. If you compare even Judge Kethledge's dissenting opinion in the Sixth Circuit, where he's saying this is narrower than the government says, he doesn't focus on legislative history. Certainly the majority didn't. Certainly the Chief Justice Roberts doesn't. As I said, very textualist opinion. But the Ninth Circuit opinion in a case called IP, that was an opinion that just went straight to the legislative history. The language is unclear. Let's see what the committee report said, and so on. You don't see even a whiff of that in these opinions at the court. And what I, as a tax lawyer, think is interesting is there's a way in which the tax bar seems to be one of the last bastions of legislative history in the profession. Tax lawyers are more likely to want to look at it than many others are. But you can see here, when the Supreme Court is looking at this issue, they have no interest in the committee reports. They're not referred to at all. So, one, the Ninth Circuit loses. Two, textualism wins. And then I'll finish with the third, which is not about the opinion itself, but about the policy. It's interesting, the Wall Street Journal ran an editorial, I think it was last week, about this opinion just after it came out, pointing out that the Biden administration had just allocated many billions of dollars for additional tax enforcement to the IRS, and pointing out also that this opinion just emphasizes how much authority they have, and the fact that it does seem like they are potentially abusing this authority. It is a strange thing to go to a law firm and say, we want to see your bank records. What about attorney-client privilege? What about the fact that, in some situations, lawyers aren't even supposed to talk about who they represent? And yet here comes the IRS demanding bank records about a lot of things. Who knows exactly what the limit of that is? The Journal does not criticize the court. I think the Journal has a lot of sympathy with the textualist approach that the court takes. So the Journal says, go to Congress. Congress has to fix this. This is an abuse waiting to happen. It's a scandal waiting to happen. The IRS should not have this much power. So I think we'll see, one, what the next case the court takes will be, and on this issue, and whether they do try to set some bounds, perhaps anchored in that phrase, aid of collection. What do you really need in the aid of collection? But also, we'll see if Congress eventually intervenes here as well.
All right, Professor Schizer, thank you very much for breaking down the decision in Polselli.
My pleasure, Justin. Great to be here.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.